Welcome to Crash Course Injury Law with Joe Ghabour.
Hello and welcome back to Crash Course Injury Law with Joe Ghabour, founder of Joseph M. Ghabour and Associates. Joe is a personal injury attorney licensed in New Jersey, New York, and Florida who helps people injured in car, truck, and rideshare accidents understand their rights in plain English. My name is Kevin Rosenquist, and today we're unpacking what happens when an Uber or Lyft is involved and which insurance company actually pays. Joe, good to have you back.
Thank you for having me.
Yeah, it's obviously a very interesting conversation because we all take Ubers, at least most of us do, or Lyfts or whatever your preference is. Could you explain what makes rideshare accidents different from a regular two-car crash under New Jersey law?
Yes, absolutely. So rideshare accidents are very different from normal two-car crashes because of how New Jersey law treats Uber and Lyft. So unlike taxi companies, Uber and Lyft don't own the vehicles, and their drivers are considered independent contractors, not employees, which basically means you're not usually suing Uber or Lyft directly, but you're pursuing a claim against the negligent driver and whatever insurance coverage applies at that moment. So the Transportation Network Company Safety and Regulatory Act sets strict insurance guidelines and requirements for rideshare vehicles. And the coverages change depending upon the driver status in the app, which adds a whole other layer of complexity that you don't normally see in regular automobile accidents. The biggest difference is that depending on when you accepted the terms of your rideshare app as a passenger, you may not even be able to file a lawsuit. You may have to go through arbitration. A 2024 New Jersey case found that arbitration clauses in the rideshare app are valid and enforceable. So the case must be resolved through arbitration. So it's very tricky, and it's a lot different than regular automobile accidents.
There's different situations too, and I'm curious how coverage would work for the rideshare driver themselves, because you might have the app off, you might have it on, but you haven't picked up a passenger yet, or there might be an active ride in there. How does this affect whether coverage works or not?
So the insurance coverage in a rideshare accident, like you said, completely depends on what the driver was doing at the time of the crash. And this is broken down into kind of like phases. So like you indicated, is the app on or off? So phase one, the app is off and the driver is using the car for personal reasons. So in a situation like that, if the Uber driver gets involved in an accident because his app was off, his auto insurance would be primary, and there would be no other insurances available from Uber or from Lyft for your damages. Phase two, if you will, is when the app is on, but the driver is actually waiting for a ride. So Uber and Lyft must provide limited liability coverage to protect others. And this is done because New Jersey requires that the drivers carry at least $50,000 per person in bodily injury liability, $100,000 per accident, and $25,000 in property damage. Now, this is higher than the state minimums in New Jersey, but if you're using your car for this, it is required. And if serious injury occurs, the injured person will have to go through their own uninsured and underinsured motorist coverage if the offending driver doesn't have sufficiency of coverage.
Okay.
The third phase is basically if you're in the car, if you're a passenger during the ride itself, while he's picking you up, while he or she is dropping you off. That is the highest level of insurances. That's when actually Uber and Lyft's rideshare insurance kicks in. The law requires them in New Jersey to carry a $1.5 million liability policy. It also requires them to carry a 1.5 uninsured and underinsured motorist coverage as well. And this is really so that in the event the driver of Uber is not at fault and they get involved in an accident with somebody who is at fault, who's a regular, driver, and that person doesn't carry a lot of insurance, then Uber or Lyft's rideshare insurance, underinsured, uninsured motorists would kick in up to a $1.5 million liability limit, which is great, actually.
Yeah, that's a big number.
It is.
Yeah.
It is, and it's done because, again, you need to make sure that if someone is injured in a service that you provide, that there's sufficiency of coverage to make sure that they are compensated well for their injuries.
So when people are in the car, is whose policy would pay first if there was an accident? Is it always going to be Uber in that scenario before, because of the fact that the person wasn't technically driving, I guess?
Well, the question pays first for what exactly? For compensation or for medical treatment? So let's talk about medical treatment. Again, because New Jersey is a no-fault state, the passengers would have to go back to their own auto insurance for medical treatment payments, for personal injury protection payments.
Okay.
It seems a little weird that that's how it would work, but again, because it's a no-fault state, the passengers would go to their own insurance first. If they don't own a car, they don't live with a if they don't own a car, then if they live with a relative who does own a car, you would go through the relative's PIP insurance. If the relative doesn't have PIP insurance, then you'd go through the PIP insurance of the car that you're in. So that's just for medical payments itself. In terms of compensation, it depends on who's at fault. If the Uber driver is at fault, then you have the $1.5 million liability available to you. If the other driver who gets involved in an accident with the Uber driver is at fault, then you would have to go through their insurance. And if they don't have sufficient insurance, then Uber's UIM coverage would kick in.
Okay. Well, I still think that's so interesting that you could not even be driving and still have your car insurance be the one that kicks in.
That's the no fault system for its good and for its bad. Again, the reason being, and we discussed this in another episode, the reason being is, if you're at fault, who's going to treat you? Well, that's why your own insurance would treat you anyway under the no fault system.
What about people either in the other car or even pedestrians or cyclists that get hit by a rideshare driver? How does their claim fit into the coverage layers?
What phrase of the accident is the Uber driver in? So if the
Right.
Uber driver is just sitting there waiting, or is going to get lunch or something and is not on the app, then the Uber driver's own insurance is going to cover it based upon his limits. If the Uber driver is waiting for the ride and the app is on, there's going to be that higher limit, but it's not going to be the 1.5 because he's not actively working technically. And of course, if he is in the car with an Uber passenger or a Lyft passenger, then Lyft or Uber's insurance of 1.5 million limit would come into play.
Okay. Do there end up being disputes and finger pointing between when multiple insurers are involved, between personal and commercial policies and all that? It seems kind of complex.
Anytime an insurance company can find a way to avoid paying, they will avoid paying.
Right.
So there are always going to be, finger pointing. The insurance company for the driver of the Uber vehicle is going to say, it wasn't my fault, it was the other guy's fault. The other individual is going to say, it wasn't my fault, it was the Uber driver's fault, and everybody's going to look for any way to get out of paying. So a lot of things come into factor, whether the driver was logged into the app, whether the trip had already begun, whether the injuries actually qualify for coverage. And again, we've discussed this before, that in New Jersey, if you have PIP coverage, your insurance policy will dictate what injuries you need to show in order for you to be able to sue the offending driver. So if you have a limited right to sue threshold, then guess what? If you don't have a lot of injuries, or injuries as defined by the statute, basically severe injuries, you can't sue even if they're 100% at fault. So again, there's any way that they can avoid paying, the insurance companies will jump on that and try to get out of it.
When fault isn't clear, for example, both drivers share some blame, how does comparative negligence affect the payout in a rideshare case?
Well, comparative negligence in New Jersey, whether it's a rideshare situation or not, it's all the same. Whatever percentage of negligence is attributable to the plaintiff in this matter is going to be reduced from his compensation, provided that he or she is not more at fault than the other driver. So comparative negligence, basically, very simply, whether it's rideshare or regular, if you are more than 50% at fault, you can't sue the other driver. If you are less than 50% at fault, then your compensation will be reduced by the percentage of fault attributable to you. So if it's 10% to you, and the case is worth 100,000, you're going to get 90,000, and that's how that works.
So in these cases, you're never really dealing with Uber or Lyft. You're dealing with their insurance company, right?
Yeah, you're never going to deal. The companies, obviously, Uber and Lyft are huge companies,
Sure.
and they're well insured for that reason. They're not going to deal with little complaints coming here and there. Secondly, you're not actually suing Uber and Lyft. You're suing the driver of the vehicle who was involved in the accident. And this, by the way, happens for pretty much everybody. So unless there is a reason to bring in Uber or Lyft into the lawsuit, so for example, there are situations where you can sue Uber and Lyft if, for example, they do not properly vet their drivers, if they allow their drivers to have violations, and they forget to go back and to check to see how their drivers are doing, or if God forbid one of their drivers is involved with any sort of kidnapping or any criminal activity, and they let them drive, well, that becomes a big problem for Uber and Lyft. And more often than not, obviously they're not going to allow that to happen, but if it does happen, then you have the legal right to go after Uber and Lyft individually.
Okay. Yeah. Yeah. That makes sense because then it's like it's negligence on their part, not doing their due diligence to ensure safe drivers on the road.
Absolutely, negligent hiring, negligent supervision. I mean, there's a whole bunch of things that they can have issues with if they don't do what they're supposed to do.
Do you change your strategy? Does your approach change when it's a rideshare situation? If you're defending somebody who, if you're representing somebody who was, in a car that crashed?
We work up every case at my firm as if though the case is going to trial. So when we get retained, everything that we do is done with the fact that we are going to try the case if we need to. So we prepare very well in these situations. We get all the medical records, we get all the, if we need liability experts, we do that. Whatever is necessary to make sure that the case is properly prepared to go to trial. Having said that, whether it's Uber or whether it's a regular automobile driver, whether it's a regular insurance company, whatever the case may be, they're all prepared the same way. We have to prove liability, we have to show damages, and that's really going to be these are the things that we have to show to make sure that we have a successful case.
You're a New Jersey, New York guy. Is it different than the way taxis are handled?
Well, taxis more often than not are actually owned. The actual car is owned by the person driving it. More
Oh,
often
I
than
didn't
not,
know that.
yeah, they have a medallion, and of course, now we're talking about rideshare. The rideshare market has kind of destroyed the value of a lot of these medallions,
Sure.
especially if you talk about New York City. But more often than not, the driver of the taxi is actually the owner of the medallion and the owner of the actual yellow cab itself, or whatever cab color it is, depending on the area that you're in, whether it's New York or New Jersey. So in that situation, you're suing obviously the owner of the car, you're suing the driver of the car, which is usually the same person. So it's a little different. And again, the reason you're not suing Uber and Lyft is because they don't own the car. So usually when we file a lawsuit, we file a lawsuit against the driver and against the owner. And we do that because we don't know what caused the driver to be driving that car at the time, whether he's doing something at the request of the owner, or whether he's just borrowing it as a friend, or we don't know until we're actually in the case. And at that point in time, we can make a determination whether the owner of the vehicle needs to stay in the case, or whether they can be dismissed out because they have no liability.
What about when it comes to things like shuttles, to like airport shuttles, things like that? They're kind of in the same family, but obviously those most of the time are fleets of vehicles, things like that. So how does that change how these cases unfold?
Well, when we're talking about shuttles, it really matters who owns the shuttle for a variety of different reasons. Obviously, if it's like a parking facility that shuttles people from the parking facility to the airport, those are usually privately owned. But if you're parking, for example, in JFK or Newark Airport or LaGuardia, in their own parking lots, chances are the shuttles are owned by the Port Authority of New York and New Jersey, which has its own requirements for notification and its own statute of limitations to go after them in the event the driver is negligent. And of course, in a situation like that, you would be suing the driver of the vehicle or the shuttle and the owner of the shuttle as well. And it would work the same for private parking lots as well, where you would also be suing the driver of the shuttle and the owner of the shuttle, because the driver is working for the owner and doing whatever the owner is asking him to do, we're asking her to do. So both parties get named in a lawsuit.
Does it get super complicated if a shuttle crashes and it's got like 5 people in there? I mean, as far as how to divvy up the money, or does everybody get their own shot at it?
Well, okay, so most often than not, the insurances for shuttles is substantial because it's a commercial policy. It's not like, a regular person's, personal policy. It's a commercial policy. So they usually are more $1 million or above.
Okay.
Every individual that files a lawsuit for compensation is going to be compensated based upon their injuries. So obviously, the more severe the injuries, the more the compensation is going to be up to the limits of liability. And more often than not, an insurance company is not going to settle one case when it knows there's like 10 other cases outstanding from the same accident until they have a better grasp on, who is injured and how severely that person or those people are injured, so they can, make offers, commensurate with the injury levels.
Okay, that makes sense. That makes sense. All right. Well, thanks for that, Joe, and thank you for tuning in to Crash Course Injury Law with attorney Joe Ghabour. To learn more about how New Jersey's rideshare laws work and what to do after an accident involving Uber or Lyft, visit GhabourLaw.com. You'll find straightforward resources on insurance coverage, medical bills, as well as your rights after a crash. Thanks again, and don't forget to subscribe to our channel and leave us a review. We very much appreciate it. Joe, really great chatting with you as always. Thanks for being here.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.